Welcome to SpringLaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
Good morning, everyone, and welcome to our Spring Forward Legal Updates monthly webinar series. Hopefully none of you can tell that behind the scenes we are dealing with some minor tech tangles and that Emily and I look super calm, cool, and collected, and we're ready to go and happy to be here. So we have a large number of people attending our webinar today, which is a little disconcerting because we're talking about managing toxic employees, and that, you know, as employment lawyers, we do deal with these issues, but I think the COVID impact is taking its toll on workplaces, and the level of interest today is a little disconcerting, and hopefully we can give you some tips to take away to help you in dealing with these kinds of things. I'm Marnie Baisley. I'm one of the lawyers at SpringLaw. I'm joined by Emily Sue, and if you're one of our clients, you already know that we're employment and contract lawyers at our virtual firm based here in Ontario. And welcome to those of you who are new. If you would like to download the slides, they're under our handouts tab. A couple more housekeeping items. If you want more info about our law firm, our website is great, springlaw.ca. Our award-winning weekly blog posts are all there. We have a publication for COVID-19 for employers. It's a very handy guide that's regularly updated by our amazing team. We've got a link to subscribe to our monthly newsletter, information about our innovative subscription program for employers, and also an ebook for employees who've been recently fired and are looking for a DIY approach or an alternative to in-person legal services. Okay, let's jump into today's content, and Emily's going to run through the roadmap.
Thanks, Marnie. So we'll begin with a presentation roadmap to outline the contents of this webinar. So to begin, Marnie will provide an introduction on policies, followed by an overview on the purpose of policies as well as examples of policies. I'll then dive into when to use policies, what's in them, and how they should guide your business practice. We'll then circle back to Marnie. We'll talk about what isn't in policies and that ought to be considered when managing toxic employees. I'll follow up with guidance and tips on where to go and what to do when you as an employer are faced with employee misconduct and have to determine the best disciplinary approach and mode of implementation of discipline. Marnie will then speak about management of high-level employees. I'll discuss best practices, and Marnie will conclude with takeaways and final thoughts. Over to you, Marnie.
Okay, sounds like a plan. I'd like to start first by talking about the higher level policies that organizations often typically have in some form or another. And what I mean by those are codes of conduct, codes of ethics, maybe mission statements that appear at the beginning of an employee handbook. D&I policies and initiatives are very popular and on the rise these days. Whatever they might be called, organizations are, it's advisable certainly to have some kind of language that defines your workplace culture and key values in the workplace. Obviously, there's going to be a whole variety of values within a workplace, but the key values that are going to help drive employee treatment of each other, and I guess, for lack of a better phrase, the vibe in the workplace to a degree. So we start with those policies, and in a perfect world, everyone gets along and it's an entirely respectful workplace, but we all know that's not life, and there conflicts arise and there is discord in most workplaces. So let's talk about the more detailed policies, and we're going to get into, like we said, some best practices and tips on how you deal with these inevitable issues that happen in workplaces. So in terms of policies that have a little more meat in them in terms of how to address workplace conflict, as opposed to the bigger, higher level statements that I was referring to in codes of conduct type policies. These policies are your starting point as an HR people ops professional dealing with workplace conflict. So when an incident arises or conflict arises, the first thing to do is to refer to any applicable policy, figure out what you have in place, pull it out, and use it for guidance as a first step. Often when we get called by clients, the first question is, what policy do you have in place? Let's take a look at it and see what early steps might be in there to take. So some examples of, again, they're called all different things, but maybe a respect in the workplace policy might be the title, or anti-harassment, anti-discrimination policy. Social media policy often has content that's very applicable these days, with many workplaces having staff work from home, and online misconduct is a live issue. So that might be a policy with some guidance and content that's useful. Progressive discipline policies might be in place too. Emily's going to get into more detail about what sometimes or is in these policies and what's recommended to be in these policies. But that's what I'm talking about in terms of the more granular policies that you're going to take a look at when something comes across your desk or screen that you need to deal with in terms of employee relations. So the first thing, actually, before a conflict arises, what HR people ops professionals, what I always recommend to do is make sure that your policies are up to date and compliant, and that they make sense for your organization. So check in every 6 months, year, make sure that they align with a workplace that might be evolving and changing. And in compliance is obviously, we're lawyers, so we have to talk about that. Make sure that they're compliant with legislation. Occupational Health and Safety Act in the last few years has had some pretty specific requirements around harassment policies. And I've just put in, just as an example, a helpful link that talks about harassment programs and harassment policies. And it's a very good tool for those who might not be familiar with what's required. But there are lots of great resources. The Ontario Human Rights Commission has great resources as well. So ensure that, check in on your policies, be familiar, so that when something surprises you, it might be an urgent matter that's come up, you have some background about where the guidance is and what's in your policies. And when you do review them, have an eye to, okay, what are the updates that might be needed, or how might we want to tweak this, and try to picture conflict arising, and okay, does this make sense, or do we need to revise this? And the one thing I always, when we're asked to revise policies, ensure you have some level of employer flexibility in your process. So while I've said it's your starting point, pull out your policy, it may guide you, it hopefully will guide you to some degree. We don't want policies that are so rigid with a whole lot of mandatory language where you're bound and you can't look at it as a case-by-case situation and depending on the facts, and you're stuck with a policy that's too rigid and that might expose the employer later to a complaint or an allegation by employees counsel that the employer breached their own policy. They didn't follow this. It said that this process had to happen. It had to happen within 10 days. These ex-witnesses would be interviewed and so on. Just too much detail can be rigid and can bind the employer too much. So you want to have a policy that's helpful, it provides guidance, and it can be applied consistently across your workforce, but you don't want to be too restricted and to have the ability to deal on a case-by-case basis depending on your facts and how serious the matter is. And then the last bullet is follow them. So always check that to make sure that you're following the policy, and it may not guide you, it might not have language that says you have to do this or that, but you don't want to be in a situation where the policy is attached to a human rights complaint and you're the person who didn't pull it out and missed some timelines or missed something that was in a policy that is part of the employment contract for the employee. They've agreed to this and this is what they're expecting in terms of handling a matter when a conflict arises. So follow the policies.
So what happens when you as an employer are made aware of employee misconduct? Well, the first thing you do is pull up your policies. And what should you expect to see in these policies that you pull up? What should be included in these policies? Well, you should see an anti-harassment or anti-discrimination policies, and this is sometimes known as the respect in the workplace policy or harassment policy, etc. You should also see a domestic violence policy. So something along the lines of, if the company becomes aware or ought reasonably to be aware that domestic violence would likely expose an employee to physical injury may occur in the workplace, the company will take every precaution reasonable in the circumstances for the protection of the employee or others in the workplace. In these policies, it's helpful to have definitions and examples to address situations of misconduct and assess next steps. So for example, an explanation of what discrimination encompasses, examples of what this entails. For harassment, you might use the Ontario Human Rights Commission definition, which indicates that harassment, quote, means engaging in a course of vexatious comment or conduct that is known or ought reasonably to be known to be unwelcome, in conjunction with the Ontario Occupational Health and Safety Act definition of workplace harassment as, quote, engaging in a course of vexatious comment or conduct against a worker in a workplace that is known or ought reasonably to be known to be unwelcome, or workplace sexual harassment, end quote. So examples of what constitutes harassment are also useful, less common examples especially, such as spreading gossip about an employee. Sexual harassment should also be covered in these policies, along with bullying, workplace violence, as well as reprisal. A policy will also guide the employer on issues such as the complaint process, the investigation process. With respect to the investigation process, you want to look into what is required under the Occupational Health and Safety Act, specifically when it comes to harassment. The Occupational Health and Safety Act requires that the investigation conducted is appropriate under the circumstances. So employers have the duty to investigate whenever they become aware of workplace harassment, whether this investigation is formal or informal. The employer should talk to the employee who was allegedly harassed, the alleged harasser, as well as relevant witnesses. And as Marnie talked about earlier, many policies will say that if there's harassment, an investigator will be retained and they'll meet with the employer or employee in X number of days. But the policy should instead, as Marnie said, say something along the lines of an investigation into the incidents and complaints of workplace harassment that is appropriate under the circumstances will be conducted. And this follows the legislation and allows for flexibility. So that's important, having flexibility. It's also important to keep in mind that a worker who has allegedly experienced harassment and the alleged harasser, if they are a worker of the employer, will be informed in writing of the results of the investigation and any corrective action that has been taken or that will be taken. A policy should also advise on confidentiality, and this is a big thing. So indicating how an incident or complaint will be kept confidential to the extent possible, but cannot be guaranteed. And the policy should also include what happens after the investigation in terms of the process, so that, for example, the parties are advised of the outcome in writing, as mentioned previously. And the employer may also wish to include a progressive discipline policy. So with the progressive discipline policy, this should outline discipline steps. You might consider beginning with a less severe consequence for a first offense. This would not be appropriate in situations involving more egregious conduct. So conduct that is of a sufficient degree and character to cause an irreparable breakdown of the employment relationship, in which case the incident may be sufficient to warrant a more severe consequence, including termination for cause. You might move on to the next step of warning the employee that further misconduct will result in more severe consequences, such as through a performance improvement plan as a way of warning the employee. And you have to ensure that you give the employee the time and assistance necessary in order to meet these expectations. And if the employee doesn't improve, you might consider you should impose rather increasingly severe consequences for subsequent offenses. And this would be followed by a provision of a final warning that further misconduct will result in more severe discipline, including dismissal for cause. I'll turn it over to Marnie now, who will discuss what is not in policies, but should still be considered.
Thanks, Emily. So we started out talking about follow the policies, know what's in them, and stick to them. But there are a lot of steps that aren't set out in policies, and where you have to figure out, okay, what do I do now? This has come to my attention, and I need to respond. And what do I do? So we can't emphasize enough the importance of early planning, because you know, if you find that the issue is serious enough that you have to retain a third-party investigator, for example, sometimes it's difficult to find an experienced trained one who's available as soon as you need, depending on the severity of the situation and so on. So it takes early planning to figure out the path you're going to take, and figure out who you're going to collaborate with on the leadership team or on your HR team, and have those discussions early to figure out the level of severity and what does this require. And as Emily said, and this is a very important phrase to remember, the legislation requires that an investigation be conducted that is appropriate in the circumstances. So we're big at SpringLaw in really assessing, does this warrant an immediate knee-jerk third-party investigation, because they're quite involved, they're formal, they can be expensive quite quickly, or is there a path for a compliant and effective result without going that route? Sometimes a matter it requires an investigation, there's a harassment complaint involved, and the legislation requires investigation, but it can be handled, it actually can be handled internally in a fair way, but it really takes a lot of thought to be sure that you're well, as sure as you can that you're taking the right path. So plan early, document all the steps that you take in this planning process, because again, investigating is a requirement. So you want to be able to demonstrate what you did. And the investigation might be something that's fairly minor. It might be more like a review of what went on, and that would be your quote unquote investigation under OSHA. So you want to have a record of what you've done, especially if it turns out to be a less robust investigation, where you've come to the decision that we're done and we've done what we need to do, and we feel like we can move forward in a positive way, and we've fulfilled the obligations under legislation. So document the steps you take. And I did miss the word discreet. Obviously, you want to be discreet, especially in high charge sensitive matters. I think that goes without saying, and we all know that, just to be extra sensitive around confidentiality. In terms of documenting all steps, we always have to be careful in a fact-finding process to avoid prejudging the issue. I mean, people might have biases or views about certain employees, or there might be a recurring pattern of some sort that preceded an incident, and you have to park that and conduct an investigation with a clean slate, and because that's the investigation, that's what's required, and that's what will be defensible as an employer. So you want to make sure that you have a prompt, thorough, and defensible process. And when documenting steps and avoiding prejudgment, be careful what you might comment in documents, because a document that appears in an affidavit of documents or in a legal proceeding later that has a comment that suggests someone prejudged the issue without knowing all the facts can be very problematic. So be careful about what you're documenting. You're documenting your process. You're this defensible process that is going to be procedurally fair. It's going to have some thought gone into it about who's going to investigate, and are they neutral, and are they not only neutral, but are they perceived to be neutral? Are they sufficiently distanced and third-party arm's length from what's going on and the people involved? And you're going to look at your whole plan and say, okay, is this going to be defensible? And I think that the last bullet's very important. The standard is reasonableness. It's not perfection. So that's where the early planning with trusted team members about where you're going to go is important. And if you don't get it perfectly, but you can show that you are careful and you put thought into it and you're aware of the legislative requirements, then that's a standard that's required, the standard of acting reasonably.
Okay, so we'll move on to addressing the misconduct now. So when, as an employer, you've obtained the facts through a review or investigation, what do you do next? So courts have very helpfully given guidance on how to address the misconduct when it occurs. And so with respect to determining the appropriate disciplinary measure, it's important to take a contextual approach. So you'll consider 3 important factors, the first of which is the nature and seriousness of the infraction. Asking questions such as, does the misconduct go to the core of the employee's responsibilities? Is it incompatible with the employee's duties? How does the misconduct affect the employer's business is also important. So for example, banks, which highly prize financial trustworthiness, may find that a small incident of stealing from a client's account would tarnish the bank's reputation. You might also consider whether this misconduct was an isolated incident or whether it follows a recurring pattern of behavior. Whether the employee had a lack of skills. So if so, an option for resolution might be counseling. Whether there's a likelihood of correction is also something to consider. The second aspect of this contextual approach is the surrounding circumstances. And some of these circumstances will mitigate against more severe discipline, and others will call instead for a greater form of discipline. Some surrounding circumstances to look at would include the employee's employment history. And so an employee with a great length of service and also a clean discipline record will often mitigate against harsher forms of discipline. You can also look at the discipline history of the employee, as well as any policy requirements. So look at whether the policies provide guidance or direction with respect to discipline, whether it be for the types of discipline available or the circumstances in which discipline is imposed. It's also important to look at the terms of the employment contract, as well as the probationary status of the employee. So if the employee is on probation, a harsher form of discipline may be justified compared to an employee who acted similarly but is no longer on probation. Personal circumstances should also be considered for the employee. So a disability affecting the employee's ability to carry out tasks of their employment, other personal factors, etc., should be looked at. And if the employee's circumstances are related to a protected ground of discrimination, the employer may be required to accommodate the employee to the point of undue hardship. Otherwise, the employer risks violating the employee's right to be free from discrimination. Workplace circumstances are also important. So high-level position employees generally have higher levels of accountability. Management must lead by example, and a breach of trust and abuse between a high-level manager and a subordinate will often call for more serious discipline. But it's also important to remember that if the expectations around an employee's performance haven't been clearly communicated or are unreasonable, or if the training is inadequate, then the severity of discipline will likely be lower and the situation may call for an alternative form of discipline or even a different solution altogether, such as counseling or retraining. So the third factor in terms of a contextual approach to consider is the proportionality element. So as they say, the punishment should fit the crime. In other words, the severity in the form of the discipline should fit the misconduct, and there should be balance between the two. It's important to keep in mind, though, that the courts are rarely determined that for-cause terminations are justified when a less severe disciplinary measure could have sufficed. So it's important to keep that at the back of your mind. I'll now hand it over to Marnie, who will talk about management of high-level employees specifically.
Thanks, and I should say that I forgot to mention that you can put questions in the chat, and we should have a couple minutes at the end to address them. I see a couple now, and we will have time to get to a few of them, some questions in there. Okay, management of high-level employees. That's actually what brought us to this topic. The high-profile Governor General situation was quite unfortunate and led to a bunch of questions about toxic workplaces. So how does management of high-level employees differ? We've been talking about procedural fairness and consistency in following policies. So I'm going to say a consistent process for all employees, regardless of their level, is important. Unless there is a specific policy for senior level managers, which that might be the case. So again, let's go back to whatever policies apply to the employees that you're managing. But in many cases, it's one policy that applies to the workforce. And apply that process consistently regardless of who they are. And it's important to ensure that reporting options exist in the complaint process. This is one of the Occupational Health and Safety Act amendments from a few years ago, because there were issues around people being afraid to come forward because they didn't have an independent route to complain. And that's what happened in the Payette matter, where the complaints were going to her second in command, who she had a friendship with. So clearly problematic. So you want to make sure that employees know that they can report, who they can report to if they're complaining about somebody, who they can submit a complaint to, if they can complain about somebody who they're reporting to or is too close to their role somehow. And it's important to keep in mind that complaints aren't always formal written complaints, and the higher level the employee is, who's the alleged toxic employee, call them, the more afraid typically employees are to get to the point of complaining. And by the time they do complain, things have probably gotten pretty toxic. So HR and people ops, they're well advised to keep an eye on things and just check in and make sure that a bunch of negativity and toxicity is not happening under their nose, where it could be prevented early on. So yeah, it's not always a formal written complaint. The obligation to investigate allegations of harassment can come in many different ways. So yeah, the process for management employees shouldn't differ, but the outcome may differ because of the seniority of senior people being held to a higher standard. They're leaders in the organization, and the outcome and the steps and the kinds of things that Emily's been talking about, that might be different. And that's, in my view, the one thing that might differ for management level employees, the consequences and the outcome. But procedurally, it's the same process. I mean, there might be, again, it's always case by case and contextual. There might be, you know, communication strategies or concerns about PR that require a different approach, or interim measures that might be different because of the level of seniority of the employee. But that's all going to come out in your early plan with your, you know, the discrete early collaborative plan with other leaders early on. You're going to figure all that out. But they should be, yeah, in a nutshell, a senior employee should be treated the same in terms of process.
That's great, Marnie. So best practices. So I'm going to summarize a few tips and points of guidance in terms of managing toxic employees. So the first point I have is to frame to employees any kind of criticism as feedback. A lot of the time, employees who misconduct themselves aren't even aware that their behaviors are destructive or cause as much toxicity in the workplace as they do. These employees are so focused on themselves and their own needs and their wants to be aware of the broader impact of their actions. So framing criticism as feedback with a goal toward which the employee can work can actually assist very greatly with helping the employee improve. However, an employer must be very clear about the consequences. The employee needs to know that their job is in jeopardy, especially if the employee is acting in a way that is leading them down the road to termination with cause. Terminations with cause are quite hard to establish with performance-related misconduct. So ensure that you as an employer are crystal clear in your communications, preferably written communications. You might also want to consider separating the toxic employee. So whether that means virtually, especially now given the prevalence of work from home setups, by, for example, minimizing the interactions between the employee and others, or physically, for instance, if two employees share an office or workplace and one employee makes a complaint to HR about the other's behavior, the employer could not only physically separate the employees, but also rearrange the seating arrangement of the entire company if it's a small company, or a portion of it if it's a larger company, in order to maintain confidentiality about the complaint. And at the end of the day, you might have to accept that some employees won't change, and whether that is because they're unwilling to or unable to, you have to be prepared to deal with these employees. Why invest your time and resources into trying to handle the toxic employee and make all of the non-toxic employees tiptoe around the toxic employee? You should cut your losses before more irreparable harm is done. And another tip is that employers may also want to consider hiring a professional coach or other third party. This is something that's gaining a lot of popularity very quickly nowadays. And there is value to it. You can consider the value of professional coaches, executive coaches, people who help with workplace restoration, as well as people who do culture assessments. So that includes anti-oppression consultants and educators, etc. And these third parties will offer a variety of different types of services depending on the nature of the conflict, the number of people involved, and so forth. And sometimes they can provide a much needed, fresher perspective from the outside, and this can be very helpful if the employer wants and is able to make that investment. So I'll turn it over to Marnie for some takeaways.
Okay, just to recap the high notes here. So starting with policies, make sure you're familiar with them, you know where they are, which ones you have in place. Make sure they're compliant with legislation because it does change, and are they applicable? Does the tone fit the organization? Is it kept pace with changes to the organization and you know, reporting structures and so on? You've got the titles up to date and all of that kind of stuff. Plan and strategize early when you have workplace discord or conflict. Document all your steps. and just have that umbrella concept of procedural fairness and impartiality throughout. It's a big mess if you don't, and you have allegations that you fast-tracked or prejudged or didn't have a fair process for an employee complaining, or witnesses or respondents. So fair process. Contextual approach, meaning case-by-case basis. It's going to vary. There's not a one-size-fits-all approach. So that early planning will help you figure out what works best depending on the severity of the situation, what interim measures might be needed, what professionals you might need to bring in, what kind of safety measures if there's a risk of workplace violence, domestic violence, etc. So assess and get as much information as you can early on to put your plan together. And again, this reasonableness is the standard, not perfection. So do your due diligence in your early planning, and that's really all that can be asked of you and your team to in handling this. And of course, legal counsel is always there to help strategize. We do a lot. I know lots of employment lawyers do help with an early strategy consult to help navigate at the early stages and figure out what that procedurally fair process looks like. It's 11 o'clock. We do have a bunch of questions. I'll jump in and quickly handle one that I don't know if you've seen yet, Emily, because you were reading, but it says, do you need to follow the process of investigation for those on probationary period? Can you simply separate them under the terms of the probation? So OSHA requires an investigation into any complaint of harassment. So, and the purpose of that is to eradicate harassment in any workplace. So regardless of which employee is making it, or if your probationary employee is a respondent, there still will be an obligation to conduct an investigation. But you'll want to look at the terms of your probationary period, and you might have more flexibility there if it says the probationary employee can be terminated for any reason without notice during the probationary period. That will guide you on how you can handle the probationary employee, because they do have less rights as a probationary employee. So subject to, of course, human rights considerations and avoiding any discriminatory processes or decision making, they can be treated differently, but you do have the obligation to investigate still. Let's see. There's a question here about gossip, workplace. Upon reviewing the policies, there's nothing specific about gossip. Is this a common omission or just where I work? I've found management is generally adverse to approach gossip. People who gossip, as they seem to have some form of internal power. I mean, I think that including examples of what's not acceptable, you know, if you define discrimination and harassment as Emily was saying, and you provide some examples and put gossip in, or speaking in a way that's not respectful, or however you want to define it, or some policies are very informal and just say things like, if it's, you know, if you can't say anything nice, don't say anything at all. So you think it's not kindergarten, but sometimes that's the plainest way to say it. So you can certainly include that in your policy. This is about what are the core values? What are the issues that might have come up in the past? What do we want to put in here? So you have that flexibility to deal specifically with different types of behaviors if simply saying be respectful at work isn't specific enough for your workplace, and often it isn't. I mean, sometimes people don't know what's appropriate, and the harassment sometimes comes in very different forms that people don't realize is harassment. And so giving examples of misconduct or the kind of inappropriate dialogue like gossip it's perfectly fine. I think we might have okay, we'll do one more. We got a few questions here. What about covert bullying? Covert bullying, yeah, I mean, bullying, harassment, that it's got to be dealt with. It's going to evolve and, well, likely evolve into something worse and more hurtful, harmful. And, you know, bullying is very similar to harassment, and that quickly falls under legislation and the obligation to investigate. So absolutely, sit down, figure out your plan. And again, that investigation that is quote unquote appropriate in the circumstances might begin first with the person who's the alleged bullier or the respondent in the situation, and it might have really good communication. It might be all you need to do, and obviously a check-in with the person who is at the other end, on the other end of the bullying, but that and a documented record of how you dealt with it might suffice, but you absolutely have to deal with covert bullying. as a legal obligation, and it's advisable because it's going to evolve and become a bigger problem. I think that's all the time we have today. If there are other pressing issues, you can feel free to reach out directly to any of us. Otherwise, feel free to visit us on our website and check out all the great resources I mentioned at the beginning of the webinar. Thank you very much for joining us today.
Thank you, everyone.